Alrighty, Diesel We the People News. One more time at it. Educational purposes only. Okay, not an attorney, not giving legal advice. Alright, do your own research. Okay. Just never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Alright, arm yourself with knowledge. Now, I may have repeated myself. I don't know. It is what it is. The problem we have at hand today is that everybody has been a creature of habits. All right. They assume, all right, that attorneys are honest because you paid for it. When in fact, your attorney is helping out the prosecutor to convict you or even property tax, right? Your attorney is trying to make you do a bargain contract and be able to go ahead and keep paying on your property or keep out of jail or a limited time in jail. But the issue we have at hand, none of them is involving the due process. None of it. All right? They're completely ignoring the due process part. And especially here in Texas. And everybody just seems like these magical judges and magistrates out there that, they're not out there violating rights. And they're the ones instructing officers to violate your rights. And then when they get sued, what do? Get qualified immunity. Why? Because at least the officer tried to violate your rights. I'll tell you what, if you cannot violate the people's rights, don't worry about it. We're going to give you qualified immunity. You get to go back to your job, and you get a promotion, and turn around and violate the rights again. All right? Out of 31 million people in Texas, how many of y'all really actually know that they are ignoring the state law? And then you're going, oh, the mighty Republicans is coming to save the day. Or, the mighty Democrats is here to save the day. Okay? It don't matter if that judge is Democrat or Republican, y'all. It doesn't matter if they're magistrates. If the Supreme Court says it'll ignore certain things, then the lower courts is going to say, we get to violate people's rights still. We're going to create revenue, all right, with the fake money. Okay? Let's go.
Are only that they must be, that they're listed. The fact that I gave it to it myself nullifies all that.
Okay. The complaint may be forwarded, and this is what you say, and this is your original suit. This is without my changes to it. Said refusal to perform under defendant's contract with the state had the effect of shielding the accused from prosecution in violation of the Texas Penal Code, which reads as follows. And then you go into hindering apprehension and prosecution. But you just make a said refusal. You don't differentiate between the two sections of this statute.
I don't care about the first section of the statute.
But
it's not.
You cite it. That's my point.
It's still not relevant to the consideration. I don't have to prove up something because it's in the law. I couldn't chop up the law and only put part of it in there. I had to put all of the law in there. So I just left it in there. I didn't cut it apart. When I quote the law, I quote the law. I don't go quote pieces of it.
Well, the problem is when you're making it... Okay, hang on. You're also saying that it's an administrative duty, which the second part is not. It's a non-discretionary legal duty.
That makes administrative. It's administrative because he has, and this is what the Civil Practice and Remedies Code addresses: a duty over which the court has no discretion is an administrative duty.
That's out of what?
It's Civil Practice and Remedies Code. I think it's in 104.002 or 3.
Hang on, let me pull up.
I'm not sure exactly where that is. Let's look at administrative duty. But in either case, regardless of what it is, the judge was commanded specifically to do a certain thing. The judge failed to do the certain thing he was commanded to do. That's a crime in the state of Texas.
What section do you think it is?
104.002.
And when they talk about that's a crime in Texas, that is going to be what he uses some of the time, all right, is the criminal code 39.00 and then other numbers in there, right? Because that code specifically goes to the government people.
They use 104.001 for immunity, but it doesn't say immunity, it says indemnity. And then I think 104.002 was the one that said you could sue them.
State liability conduct covered. Except as provided by subsection B, the state is liable for indemnification under this chapter only if the damages are based on an act or omission by the person in the course and scope of the person's office, employment, or contractual performance for or service on behalf of the agency, institution, or department, and if the damages arise, indemnification is the interest, the person is liable for the damage solely, the person signed the manifest, the person or company. I don't see anything in here about what defines an administrative duty.
I'll have to look that up. I don't have that. What is an administrative? In Texas law. Let me go to ChatGPT. Okay, according to Texas Administrative Code 1977, administrative agencies are authorized. Responsibility of state agency commissions to be asked. I'll have to look it up. Okay. Oh wait, I should have a section in my research repository. Generally, how do you think they'll respond to it?
Well, from what I've read so far, I think they're not going to respond to it at all, other than saying it doesn't facilitate any relevant claim. But I haven't got to read through the whole thing yet. I only started going. Julie forwarded it to me right before class, so I just brought it up as a subject for the class so we could go through it last night, and I think we got to page 6, 7, or 8. I forget which. But I was going through and reading it and then looking to see what the arguments were, et cetera, et cetera. And so far, these are the things that jumped out at me, is that 1509 has both a permissive and a non-discretionary component. And they have to be differentiated between when you're making your argument.
I did. I addressed the non-discretionary.
Well, but there's nothing.
His failure.
Yeah, but
he failed.
Okay. But what I'm saying is there's nothing that points to that specific section of that statute that you're saying this is the duty he was required to comply with.
What? You need to read the rest of it then, because that is
Well, I'm working on it.
that is precisely the claim that I made.
Well, like I said, I only got up to page, at
Okay.
most, I got up to page 7, I think.
Okay, because that was precisely the issue. This was not something over which he had discretion. It says shall, and shall does not mean made by the candidate.
That's
wants to
correct.
use it.
But that is the second provision in that
That's the
statute.
one. That's the one I'm claiming.
Okay, but again, I understand, Randy, but the problem is you're not, in what I've read so far, you have not specifically stated that. You just referenced that entire statute as a whole.
Well,
I understand you're saying that it's
you're
fine to put
saying,
it's fine to put the whole statute in there when you're saying this is the statute I'm discussing. But then when you're going into the specific violation of that statute, you need to narrow it down to that specific provision.
okay, I do, but I don't, in the introduction to the case, I don't get into extremely fine detail. First, I'm going to tell them what I'm going to tell them.
Yeah, but you don't do it. You don't do it under your failure to perform claim either. That's what I'm saying. I'm sitting right here looking at the failure to perform claim on page 4. You're still citing the whole statute instead of the specific section you're claiming he didn't perform under.
Yeah. So what's wrong with that?
Okay.
I'm giving them the whole statute. I'm not breaking it up into pieces. I test lawyers all the fucking time, quoting a little tiny piece of the case and not quoting the rest. The Attorney General, first case he cites is a 20-year-old unpublished case. He cites a dependent clause from a sentence. When I pulled up the case and added the independent clause to the front of it, it changed the meaning. And then when I put the whole sentence in the paragraph it came out of, it changed the meaning again. So I put it all in there. I put the whole.
Okay, I understand, but like I say, 1509 has an issue that I honestly don't think you're noticing. The second clause, the non-permissive clause, and the magistrate who receives the same, that is a direct reference to the first clause. Okay? And that first clause deals only with a transferred complaint, not the complaint. Yes, it does, Randy.
It does not say how the magistrate receives this claim. The magistrate receives the claim.
A complaint in accordance with Article 15.05 may be forwarded as provided by Article 15.08 to any magistrate in the state. And when the magistrate receives the forwarded complaint, then he shall issue a warrant.
Yeah, I forwarded it to him by personal fucking service.
Well, again, Randy, the argument here is going to be is what is meant and intended by forwarded.
That's a ridiculous argument to bring, as it's a nonsensical argument, and that's the kind of argument the judge will say, "Are you fucking kidding me?"
Well, they may not, but you and I both know that they do that kind of shit on a regular basis. And they do it and uphold it.
I saw that part. And I deliberately ignored that part and left it to them.
Okay.
And I'm making the claim that I forwarded to the magistrate myself.
Okay.
So, I did get that part, and I didn't want to go there. Let them go there. And that isn't.
And see, and this is what I was talking about. The two different type of strategies, right? He nitpicks it, breaks it apart, and challenges it, and calls them out directly. Okay? Randy, on the other hand, he wants them to tell on themselves. Again, we're going to convert back to cops, right? Where you been? Have you had anything to drink? Right? Well, yeah, I had a beer a couple hours ago. Right? This is what he's doing. Okay? So, I understand the argument here. it's the two different strategies. I, for one, if you're going to file a complaint, you got to make sure your standing is good. And you want to be in their face about it. And don't give them any openings. More like him, right? But I do understand his section there to kind of draw it in. If he does an appeal, go to a higher judge. Well, look, this lower judge is saying that, this is not necessary, but he just told on himself and say, well, no, it's okay for us to violate your rights. So it's an interesting concept between the two ways of these people doing things in court.
And frankly,
anyway, we're going to leave that be, and then we're going to go on the other video back into the lawsuit, and then I'm going to come back to this video after that one to kind of, do the rocking chair back and forth between the paperwork and what they're saying and discussing about the lawsuit, so we may be able to get a little bit clearer understanding. All right, this is We the People News. Bye, y'all.